ये है स्टेट्स मिरर लाइव न्यूज। सुनिए आज की ताजा खबरें, झूठ होगा बेनकाब।
Today, let us discuss the defamation case of the Rahul Gandhi recently which has happened. P.D.T. Acharya is former Secretary General Lok Sabha. A strong case to restore Section 8 of 4 of the RP Act. Rahul Gandhi of the Congress Party was disqualified on being convicted and sentenced to 2 years imprisonment in 2019 defamation case. The disqualification was instant because of the Supreme Court of India's judgment in Lily Thomas versus Union of India 2013. Through this judgment, the court invalidated Section 8 of 4 of the Representation of People Act 1951, which had allowed a 3-month period within which to appeal disqualification was not take effect during this period. When the appeal is admitted, disqualification would depend on the final outcome of the appeal. Thus, under the legal provision cited, there was no instant disqualification of sitting members of the legislature. But after the court struck down this provision of the Representation of People's Act 1951, according to the opinion of some experts, a sitting legislator is disqualified the moment the court orders conviction and sentence under Section 8 of 3 of the Representation of People's Act. The top court said the Article 102 of 1 does not create any difference between the sitting member and a candidate so far as disqualification is concerned. It held that Parliament has no power to grant exemption to sitting members for 3 months and thus struck down Sentence 8 of 4 as ultra-virus the Constitution. A case with no sound legal basis, so now only Section 8 of 3 remains in the Act, which deals with disqualification of persons convicted and sentenced to 2 years imprisonment. This section simply says that a person who is convicted of an offence and sentenced to imprisonment for not less than 2 years shall be disqualified from the date of conviction. It does not say that such a person stands disqualified from the date of conviction. So there is no ground indeed to conclude that the disqualification takes place the moment the court pronounces a person guilty. The only condition is that such a person shall be disqualified from the date of conviction. So, it appears that the act of the instant disqualification of Mr. Gandhi did not have a sound legal basis. Particularly so when considered the words "he shall be disqualified," which could only mean that some authority has to officially declare him disqualified. The opinion of the writer, which was expressed in few articles, is that the authority that who can declare a sitting legislator disqualified could be the President of India exercising this power under Article 103. Although the Supreme Court did not accept this proposition in Lily Thomas in Consumer Education and Research versus Union of India and ORS 2009, a 3-judge bench held that a declaration by the President under Article 103 that the sitting member has incurred disqualification is necessary. Thus, the scheme of Section 8 of 3 scheme to be that when a sitting member is convicted and sentenced to imprisonment for 2 years or more, he shall be disqualified with effect from the date of conviction. Further, it is the President who shall disqualify him under Article 103, the Secretariat of the House to which the member belongs has no recognizable authority to declare that a member stands disqualified as soon as he is convicted by a court of law. Disqualification and sentence quantum. A question of legal importance that arose in the context of the disqualification of Mr. Gandhi was whether the stay of only sentence can lift the disqualification or whether stay of conviction is necessary. In the 1980s and 1990s, some of the high courts, Allahabad High Court in Sachindra Nath Tripathi versus Dudhnath 1987 and the Himachal High Court in Vikramanand versus Rakesh Singha 1994 had held the view that disqualification remains intact on staying the sentence, but the Madras High Court took a different view in the Jayalalitha case 2001. It held that the moment the sentence is suspended, conviction should be deemed to have been suspended, or otherwise the framers of the code would have taken care to provide for stay of conviction or suspension of conviction. Also, however, in Rahul Gandhi's case, though the Supreme Court stayed the conviction, it did not express any opinion on the question of whether a stay of conviction is also necessary or on suspending the disqualification. It must be remembered that disqualification arises only when the sentence is imprisonment for 2 or more years, as the court observed in its recent order in Rahul Gandhi's case. If the period of imprisonment was less by 1 day, the disqualification would not have occurred. It would mean that disqualification is directly relatable to the quantum of sentence and not conviction. But this is a point the lawmakers and the judiciary will have to deal with. The judgment in the Lily Thomas case play a havoc within these careers of sitting legislators in the country. Instant disqualification on conviction and sentence will upset their entire legislative career without giving them breathing space, because the court in general have a very dilatory system in dealing with appeals, revisions and such. But the case of the Agra court staying the conviction of Bharatiya Janata Party BJP MP Ram Shankar Katheria within 24 hours of conviction in a criminal case, thus saving his house membership, is one of the rarest exceptions. It is heartening that a court like the Agra section court exists in our country, but the issue of instant disqualification needs to be addressed urgently, as it may affect the career of legislators. The Supreme Court struck down Section 8 of 4 on the ground that Parliament has no power to provide for a special dispensation for convicted legislators, because Article 102 of 1 not permit such differentiation between them and the candidates. But so far as differentiation goes, the Constitution in fact permits it under Article 103, which provides that in the case of sitting legislators, the question of disqualification under Article 102 of 1 will be decided by the President. Perhaps a suitable amendment can be made in Article 102 to enable Parliament to restore the invalidated Section 8 of 4. No qualitative change. In fact, the judgment in Lily Thomas has not resulted in any perceptible qualitative change in the criminal proclivity of politicians belonging to the powerful ruling dispensation at a particular time may be able to get a conviction stayed within a few hours, thus saving themselves from instant disqualification, but others will have to wait, like Mr. Gandhi had to, for 4 months, and for the intervention of the Supreme Court just to get a stay defamation case which is non-cognizable and bailable. This and other cases show that Section 804 needs to be restored and protected. Constitutionally, in order to protect the careers of India's legislators from abrupt convulsions caused by court orders which are given in the words of the Supreme Court without any application of mind. The judgment in the Lily Thomas case, which invalidated Section 804 of the Representation of People Act, can play havoc with the careers of sitting legislators. Thank you to everybody.
ये थे आज की धमाकेदार खबरें। झूठ होगा बेखा। इन खबरों को लाइक करें, शेयर करें और सब्सक्राइब करें। थैंक्स टू ऑल व्यूअर्स।